What should you know about child support in New York? How is it calculated? Who pays and how long do you get child support? Please tune in to Attorney Joseph Marra as he explains this complicated topic.
There are basically guidelines that if states wanted federal money, they had to follow. So most states follow them. In New York, basically they calculate child support up to $154,000 of combined income. All right. Can they go beyond that? Yes. I mean, where we are here, I'm in Westchester County, one of the more affluent counties in the country. Courts typically will continue the child support calculation above that 154 combined number. How do they calculate it? Well, it's not your gross income. It's not your net income. It's a hybrid. So they take your gross income, subtract FICA, which is Social Security and Medicare taxes, and then they subtract out your either City of New York and or City of Yonkers income taxes and apply a rate to that. Now the rate varies depending on the number of children. For example, one child, 17%, two children, 25%, and so on. In addition to that, the non-custodial parent has to pay what's called add-ons. Now, what are add-ons? Well, they might be out-of-pocket medical expenses. And of course, medical insurance is very important. So that's something that's going to be discussed right off the bat, who's insuring the child. But let's just talk about the child support aspect of things. Add-ons could be out-of-pocket medical, childcare. Those are the typical, maybe, and it depends on the circumstances too. If the child had been in a private school, well, the court's going to keep them in that private school. So they're going to add that in as an add-on. If the child had been used to going to summer camp, well, they're going to continue to go to summer camp. That'll be an add-on. And how is it calculated? Who pays what percentage? Once again, they go by the combined incomes and take a percentage. So if dad makes $100,000 and mom makes $50,000 based on these calculations, dad's paying 2/3 of these add-ons as well. So you have, as I said, you have the straight child support calculation, and then you have the add-ons. That's how child support is calculated. If you're talking about maintenance, New York, we call it maintenance. It's also commonly known as alimony. Well, there's a calculator. For up to now, it basically started off, this was enacted in 2015. There's a calculator. At that point, it was $175,000. And since then, it's been up to, currently it's $192,000. And they, they go and they'll update it every 2 years. So you put your figures, joint salary figures in a calculator, and I'll determine if maintenance is paid. Bottom line is, if your salaries are relatively comparable, there'll be no maintenance. If one person is making significantly more than the other, there will be maintenance. And it's done by a calculator. If you're making more than this 192 limit, they'll go back to the old law, which has 15 factors that factor in on maintenance and alimony. And also they're going to determine how long do you pay it. Well, if it's a short-term marriage, it's going to be relatively short. If it's a longer-term marriage, it's going to be longer. How many years? It's once again a formula for that. The shorter the marriage, the less time is going to be maintenance. The longer the marriage, the more time is going to be maintenance. Also factored into that is the other party's education, the need for re-education, ability to get a new job. For example, you might have a lawyer who stayed home with her children, and now 15 years later, and she's got to go back and practice. She didn't practice in 15 years. Well, that happens. Someone else, computer tech person, and now you're having more and more men to stay home. So, I know one couple who the husband is, he had a pretty good job, but the wife was an attorney on Wall Street making quite a bit of money. So they decided he was going to stay home. And when the marriage was dissolving, he had to go back and get re-educated because his industry had, automated, computerized, and he had to be retrained. So these are the type of factors that will factor in. But For people who are making less money, quite frankly, it's a formula. When you're getting to the more people making more bigger bucks, and then you'll go back to these 15 factors we discussed for alimony. Now we're assuming that the parties are living separate and apart. They were married, and now the person with primary custody of the children wants child support. What do? We have two options. Number one, you can go directly to family court, get an immediate, before you file for divorce, you could just do that. Go to family court, file a petition. As I said, it's pretty robotic. There's a calculation. Everybody's got to produce their W-2s, and the court makes a calculation. It's usually in front of a magistrate, which is not actually a judge. It's a child support magistrate, and they will calculate it. Now, once again, if you have a situation where someone has their own business and you think they're hiding money, that might not be a good course of action. So what's the alternate course of action? Either way, when you file your summons and complaint for divorce, you concurrently file what's called an order to show cause requesting pendente lite relief, or pendent light, however you want to pronounce it, right? Relief. So what that is, it's a motion on order to show cause, meaning you're doing it yourself, ex parte. You go into the court saying, Judge, I want you to sign this order, and you want to compel the other person to come to court. And the reason why I call it an order to show cause is they have to show cause why the relief you're requesting should not be granted. In other words, Judge, I have 2 kids, I deserve, $2,000 a month for child support for these kids, and I want him to come into court and show why he shouldn't be doing that. And by the way, I want it effective the day I filed my request and the day you signed the order. All right. So those are the two options. 1, go to family court, file a child support petition. 2, concurrently with the filing of the summons and complaint, file an order to show cause requesting pendente lite relief. You get an attorney, the attorney's going to try and negotiate with the other attorney for support to avoid the motion. And a lot of times too, the courts will call you in for a conference and set a support obligation. So no, unless the person is really dilatory, they're going to get support. It's a question of the lag time between when they file the papers and when the support is granted. That's really, depends how backed up the courts are. It depends on a lot of things, but they will get their support. The question is, when is it going to start and how retroactive is it going to be? And it's really up to them. They got to file right away, and they still may not get support for weeks or months, depending on the court system, what court they file in, until they get the support, but they're going to get it all retroactive. But as I said, the key is file the papers either in Supreme or file them in family court, but file the papers.
Thank you so much, Joe, for that important information. And thank you, audience, for watching. If you yourself or someone you know may have questions on this topic, please don't hesitate to pick up the phone and call the law offices of Joseph Marra. They are professional, friendly, and really great at looking at the pros and cons of your situation, coming up with a fantastic strategy, and giving you some options. We look forward to hearing from you soon.